Hi everyone, and welcome to Truth Over News. In the ongoing and evolving saga surrounding David Weiss, the U.S. Attorney for Delaware, and the man ostensibly in charge of the Hunter Biden investigation, one thing remains clear. His story regarding his ability to actually charge Hunter has shifted and evolved, while the story from the IRS whistleblowers who outed the Hunter investigation cover-up has remained staunchly the same. If you recall, whistleblower Gary Shapley testified that on October 7, 2022, Weiss told a roomful of senior-level managers from IRS Criminal Investigation, FBI, and the Delaware U.S. Attorney's Office that he was not the deciding official on whether charges are filed in the Hunter case. This statement attributed to Weiss was totally inconsistent with public comments to the contrary from Attorney General Merrick Garland, presenting a very real problem for Garland and the Biden DOJ.
The U.S. Attorney in Delaware has been advised that he has full authority to make those kind of referrals that you're talking about, or to bring cases in other jurisdictions if he feels it's necessary. And I will assure that if he does, he will be able to do that.
Furthermore, according to Shapley, Weiss told the assembled agents in the same meeting that months before, he had sought and been denied the authority to bring felony tax evasion charges against Hunter Biden in the District of Columbia by Biden's political appointee, the U.S. Attorney for the District of Columbia, Matthew Graves. Weiss further told the agents during that October 7th meeting that he had requested special counsel or special attorney status from Maine Justice in order to bring charges in the District of Columbia, but had been rebuffed. These additional statements from Weiss to the IRS agents during that meeting are also inconsistent with Garland's public comments and inconsistent with Weiss's multiplying public comments, the latest of which were made in a July 10th response letter to Senator Graham, which we'll get to shortly. There's also the obvious problem of Weiss subordinating himself to a Biden political appointee at all. As a result of all this, Shapley testified that Weiss informed him the government would not be bringing charges against Hunter Biden for the 2014 and 2015 tax years, for which the statute of limitations was set to expire in a month. Of course, those limitations are now long past. As Shapley stated, all of our years of effort getting to the bottom of the massive amounts of foreign money Hunter Biden received from Burisma and others during that period would be for nothing. However, unknown to Weiss, Shapley's account of Weiss's statements were memorialized in an email that Shapley wrote directly after that meeting ended, noting that he believed this was a huge problem and inconsistent with DOJ public position and Merrick Garland testimony. Shapley's supervisor then confirmed the accuracy of Shapley's statements in a follow-up email. On June 7, 2023, Weiss wrote to Chairman Jim Jordan on behalf of Garland in response to questions from Jordan posed to Garland regarding his testimony that Weiss had complete authority in the Hunter investigation. Weiss, or whoever actually drafted that letter, appears to have gone to great lengths to back up Garland, stating that, "I want to make clear that as the Attorney General has stated, I have been granted ultimate authority over this matter, including responsibility for deciding where, when, and whether to file charges." Weiss's statement presented us with three possibilities. Weiss lied to his top investigators, Weiss and Garland deceived Congress, or Shapley is lying. And as we know, Shapley's account of things was confirmed by others at the meeting, including his supervisor. We also know the New York Times recently confirmed that U.S. attorneys in both D.C. and Los Angeles rejected any prosecution by Weiss of Hunter. But there's an additional, rather large problem for Weiss, Garland, and the DOJ. Weiss wrote his response letter to Jordan before the House Ways and Means Committee released Shapley's testimony and backing documentation on June 22nd. In other words, neither Weiss, Garland, nor the DOJ would have known that Shapley had that October 7, 2022 email to corroborate his oral testimony when Weiss's original statement was drafted. And it's all but certain that Weiss didn't actually write that letter, something Jordan also took issue with. This was a problem for all involved at the DOJ, as Shapley's full testimony and backing documents were explosive, including the now infamous text from Hunter to his Chinese business partners, where Hunter wrote that, "I am sitting here with my father, and we would like to understand why the commitment made has not been fulfilled. I am sitting here waiting for the call with my father." The release of Shapley's testimony on June 22nd prompted another appearance from Garland the following day, with former Obama official and current Deputy AG Lisa Monaco, the real head of Biden's DOJ, peering sternly over Garland's shoulder.
As I said at the outset, Mr. Weiss, who was appointed by President Trump as the U.S. Attorney in Delaware and assigned this matter during the previous administration, would be permitted to continue his investigation and to make a decision to prosecute any way in which he wanted to and in any district in which he wanted to.
Garland effectively doubled down on his prior testimony, saying Weiss could make a decision to prosecute any way in which he wanted to and in any district in which he wanted to. A few days later, on June 30th, Weiss wrote to Jordan again, stating that my charging authority is geographically limited to my home district. If the venue for a case lies elsewhere, common departmental practice is to contact the U.S. Attorney's Office for the district in question and determine whether it wants to partner on the case. Now, note the crucial shift in Weiss's statement. Weiss originally said he had been granted ultimate authority over this matter, including responsibility for deciding where, when, and whether to file charges. But now, in his second letter, Weiss was forced to confirm exactly what Shapley had told Congress, that Weiss did not have full authority to bring charges, but had to partner with the relevant U.S. attorney. This shift from Weiss is particularly important because Shapley, as you'll remember, had alleged that Weiss was denied the authority to bring felony tax evasion charges against Hunter in the District of Columbia by the D.C. U.S. Attorney Matthew Graves, a Biden political appointee. Now, despite earlier claims to the contrary by both Weiss and Garland, Weiss appeared to be corroborating this portion of Shapley's testimony. All of this brings us to the third letter from Weiss, or those answering on his behalf, this time in response to a letter from Lindsey Graham. Weiss was very careful in his wording, claiming that he had not requested special counsel designation, but did have discussions regarding special attorney authority, which would have allowed Weiss to file charges in a district outside Delaware without the partnership of the local U.S. attorney. Weiss claimed that he was assured that he would be granted this authority if it proved necessary. But of course, in needing to seek authority in the first place, Weiss acknowledged Shapley's claims that he was not the deciding official on whether charges are filed in the Hunter case. Weiss also claimed that this assurance came months before the October 7th meeting. In other words, Weiss acknowledged that the October 7th meeting referenced by Shapley definitely happened. Finally, Weiss claimed that he had never been denied the authority to bring charges in any jurisdiction. This means the legal distinctions between special counsel and a special attorney are irrelevant. Weiss told the IRS agents during that October 7th meeting that he had asked for authority to file charges against Hunter in D.C. and had been turned down, which leaves us with two viable possibilities. Weiss either lied to those agents or he's lying now.